if the city of New York changes the healthcare plan its retirees get, can it be sued on the doctrine of promissory estoppel? To find out, you have to read Bentkowski versus City of New York, but it's 12 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of matter of Bentkowski versus City of New York. The citation for this case is 2025 New York Slip Opinion 03690, published by the New York Court of Appeals on June 18th of 2025. The issue in this case is whether New York City's changing its retirement health plan that it's promised to its retired employees violates a promise that it made to its employees at the time, such that it's actionable as a violation of promissory estoppel doctrine. To understand and appreciate the context of this case, it's important to know that the claim, the doctrine of promissory estoppel, it's essentially, it's been around for 100 years. The concept is to provide a remedy when there's an injustice resulting where a breach of contract doesn't fit. So a contract is a formal agreement between parties, as opposed to a promise or promissory estoppel is a claim. There's elements to the claim. Basically, the elements are a clear and unambiguous promise, a reasonable and foreseeable reliance upon that promise by the party to whom the promise is made, an injury sustained by that party asserting estoppel by reason of the reliance, and an injustice resulting. And the concept essentially is if someone makes a promise to you and you rely upon that promise to your detriment, and now you can't change what happens, you've relied upon it so much that you're hurt by the fact that they've breached that promise, you should be able to recover some kind of remedy. For example, it's hypothetically, we know a tornado is coming in 2 hours. I know that's not how tornadoes work, but a tornado is coming in 2 hours and your neighbor says, don't run around building your own shelter. You can stay in my shelter. I promise you can stay in my shelter. Don't run around doing other things. And then by the time the tornado arrives, he says, you know what? I've changed my mind. You can't stay in my shelter. The person who got that promise didn't make other plans to try to become safe. They relied upon the promise, and now it's to their detriment because the person's not letting them in. So if they suffer injury as a result of it, that would be the kind of thing that would be subject to a breach of the promise, a promissory estoppel claim. You promised me something, I relied upon it. Now I can't make alternate arrangements, and now you've caused injury to me as a result of that promise that you've breached. Okay. So the last thing you have to know is that New York City has in the statute of the New York City Code, New York Administrative Code 12-126, it's required by law to provide health insurance coverage to its retirees, people who worked for the city, were vested, and then retired. The city has an obligation to provide healthcare coverage. For 50 years, they've been doing that by offering a choice of different healthcare plans. Options for Medicare eligible retirees included Medicare supplemental plans, which are called Medigap plans, and also Medicare Advantage plans, which are called MAPs. People call those MAPs, Medicare Advantage plans. And they do different things. A Medigap plan, that Medicare supplemental plan, covers out-of-pocket costs that supplement Medicare, but a MAP is a complete soup to nuts plan. It covers everything. It's not a supplemental. It's its own thing. All right. So what are the facts in this case? The facts are that in 2021, the city, New York City, made significant changes to its healthcare coverage that are provided to its retirees. Instead of continuing that process where it gave retirees options, different kinds of plans, including Medicare plans, coverage plans, MAPs, they changed it. They said every single one of our retirees is all going to be enrolled in one custom-made MAP. One custom-made Medicare Advantage plan run by Aetna. Instead of being a choice, it was all one plan that they were now going to cover. A bunch of different people, retirees, petitioners, who are 9 retirees in one organization, initiated this lawsuit, claiming that the city should be enjoined, should be stopped, prevented from making this change because it made a promise to them as employees that they would have this option that they've been using for 50 years, these different various options of coverage, not just one plan. They claim that this promise that they would be provided this array, this brochure array of healthcare plans was the promise that was made, that it was breached, and that as a result, there's injury. How is there injury? They claimed that there are higher copays involved in this plan than they would have spent. There are prior authorization requirements that they wouldn't have had to meet in different plans that they would have been able to get. Their preferred providers that were covered are not participating in the Aetna map. Some people said that they had relocated to different states. They lived in different states that don't honor this kind of plan, that don't have providers that are in this kind of plan. So they say, we can no longer, we relied to our detriment upon this promise, and now they're changing the deal. And they should be stopped, prevented from doing that. That's the claim. To prove this claim, to show that there was a promise made, they introduced summary program descriptions, which are like written brochures that are produced every single year, annually, by the city that state, through collective bargaining, this is a quote, through collective bargaining agreements, the City of New York and municipal unions have cooperated in designing the benefits for New York's health benefits program. And then it goes on to explain the different programs, the different options that they had. They show these in their proof to show that there was a promise that was made, a clear and unambiguous promise. And they also introduce affidavits from different different people. Named one Lillian Barrios Paoli, who worked in the city for HR essentially. They introduced a bunch of affidavits from former employees who said, we can no longer work. We're now retired. We made these decisions based upon the deal, the promises made to us. And ultimately, they prevailed. The procedural history here is the Supreme Court, the lowest court here, ruled in favor of the petitioners on the promissory estoppel claim and the claim that this was a violation of Administrative Code 12-126B1. The appellate division affirmed, and it goes to the Court of Appeals. On the Court of Appeals now, the holding from the Court of Appeals is this is a failure. The petitioners fail. Why? First of all, they say the Court of Appeals, which is the highest court in the state of New York, has never officially recognized promissory estoppel as an independent claim. They just put that to one side. They say the appellate divisions have recognized it, but we, the Court of Appeals, have never identified it as an actionable claim to bring. But aside from that, even the appellate divisions who have recognized it, recognize that one of the elements, as I mentioned, was a clear and unambiguous promise. And they say here, the evidence does not show that the city made a clear and unambiguous promise to provide this variety of healthcare plans. Those SPDs with that precatory language, the language that begins it saying, this is the result of collective bargaining. That's not a promise that in perpetuity and forever after, these different options will exist. It's an explanation of benefits each year that it's produced. So they say the facts here don't support a clear and unambiguous promise, and therefore there can be no promissory estoppel. The petitioners fail, the city prevails, and that's the case of the matter of Bentkowski versus City of New York. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.